Hey everyone, welcome back to all my listeners. This is episode 5 in season 12. Today is Wednesday, May 29th, 2024. My name is Sonal Patel, and this is the Paint the Medical Picture podcast series. All right, you guys, now it's been quite the month of May, hasn't it? Asian Pacific Islander Month is coming to an end. Mental Health Awareness Month is also wrapping up. And I know I've definitely enjoyed a fantastic Mother's Day and feasting on the many, many national food holidays that happened during the month of May. There was National Coconut Cream Pie Day, one of my favorites, as well as International Hummus Day. Yum. And of course, the Paint the Medical Picture podcast continues to be the #1 medical billing and coding podcast on FeedSpot since January 1st, 2024. Thanks to all of you, my loyal listeners. 69 countries tune in worldwide, and it continues to fall between the top 75 and top 100 Apple Podcasts in the US charts again and again, as well as it spends numerous weeks on top charts in Italy this year as well. So, kudos and thank you to all of my devoted fans out there. I see all of you. Now, let's get into today's episode. You know it's the last Wednesday of the month, so of course it's my Newsworthy fraud, waste, and abuse highlights for the month of May. And of course I'm going to be spotlighting some of those from the month's criminal and civil enforcement cases that I find newsworthy. And in my Trusty Tip, I wanted to highlight some new hospice claims edits. And of course I'm going to go ahead and close out and round out today's episode with another remarkable quote on collaboration by Napoleon Hill. This episode is sponsored by Advanced Coding Services. Let's get into it. Today's episode is sponsored by Advanced Coding Services, a leading medical billing and medical coding school in the United States. Whether you're just starting out or a seasoned professional, our training equips you with the tools and support you need to advance your career. Our medical billing and coding school meets your needs worldwide online or in person with one-on-one support throughout your training. We are committed to helping our alumni and credentialed medical community in keeping up their certifications by offering various avenues for acquiring your continuing education units. In addition to our Mastering the Business of Medicine retreats offered several times throughout the year in different parts of the country, we now offer memberships. You can conveniently earn your CEUs by attending our exclusive members-only webinars. Since our aim is to nurture and grow the careers of individuals who work in the business of medicine, we call our member area the Apple Orchard. Advanced Coding Services, educate, nurture, inspire, reaching back with a hand up. So let's get into Newsworthy, the month's fraud, waste, and abuse cases. The month of May saw a whopping 55 cases as of the recording of this episode. Early May saw a hospice agreeing to pay $4.2 million to settle False Claims Act allegations that it billed Medicare for ineligible hospice patients. Here, the hospice and its 5 wholly owned subsidiaries have agreed to pay $4.2 million to resolve allegations that they violated the False Claims Act by knowingly submitting false claims and knowingly retaining overpayments for the care of hospice patients in the state of Texas, who were ineligible for the Medicare hospice benefit because they were not terminally ill. The settlement resolves allegations that the hospice's Texarkana, Texas location, which previously operated under a different name, knowingly submitted false claims for hospice services provided to patients who were ineligible for the hospice benefit because they were not terminally ill. The patients at issue in this settlement were at the Texarkana location between 2014 and 2019 and again in 2020. The settlement also resolves allegations regarding 2 patients at other Texas locations between 2015 and 2021. The settlement further resolves allegations that the hospice knowingly and improperly concealed or avoided obligations to repay overpayments for these patients. The civil settlement resolved a lawsuit filed under the QTAM, or whistleblower provision of the False Claims Act, which permits private parties to file suit on behalf of the United States for false claims and share in a portion of the government's recovery. The QTAM lawsuit was filed by a former hospice employee. The claims resolved by this settlement are allegations only. There has been no determination of liability. Also in early May, a former VA psychologist was sentenced to prison for submitting false medical documents and healthcare fraud. Here, a district judge sentenced a Heron woman formerly employed in Southern Illinois as a psychologist with the Department of Veterans Affairs, the VA, to 10 months imprisonment after she admitted to submitting false medical documents, obstructing justice, and committing Medicare fraud. This woman pleaded guilty in October 2023 to one count of concealing a material fact by trick, scheme, or device, 3 counts of making or using a false writing or document, 1 count of obstruction of justice, and 1 count of healthcare fraud. Her conduct involved a multifaceted scheme that impacted her employment at the VA, fraudulent billing to Medicare, and the obstruction of a federal civil lawsuit in the Southern District of Illinois. This woman, a licensed clinical psychologist, was employed by the Marion VA Medical Center. According to court documents, between November of 2016 and August of 2020, she submitted fraudulent medical documentation in the name of real and fake medical providers as part of the approval process for reasonable accommodations and medical leave, including FMLA leave. She admitted to submitting false medical documents with forged signatures of 2 legitimate medical providers, one of whom is local to the Southern Illinois area. In addition to her submission of fraudulent medical documents, she engaged in a scheme to defraud Medicare and obtain payment for psychiatric services that she did not provide to residents of a Southern Illinois nursing home between May of 2016 and January 2018. In addition to her full-time job at the VA, she owned a company through which she claimed to provide psychotherapy sessions to patients at a nursing center in Heron, Illinois. She billed Medicare for more than 400 claims, worth more than $54,000 for services that she did not provide. She billed for at least some of those services on days when she was approved medical leave from the VA. In addition to her term of imprisonment, she was ordered to repay over $35,000 in restitution to the Centers for Medicare and Medicaid Services as repayment for her fraudulent claims. She also admitted to obstructing justice in a civil proceeding in federal court by submitting fraudulent medical documentation to her attorney, the contents of which were used to seek a continuance of the judicial proceeding. In April 2020, she filed a discrimination complaint in a U.S. District Court against the Secretary of Veterans Affairs. Rather than proceeding with this case, she submitted a letter impersonating a real physician who had practiced in Anna, Illinois, but had never treated her. Her lawsuit was ultimately dismissed by the judge. Mid-May saw a psychologist sentenced to prison for defrauding Medicaid of more than $1.6 million. This Connecticut psychologist was sentenced to 27 months of imprisonment, followed by 3 years of supervised release for defrauding Medicaid of more than $1.6 million. According to court documents and statements made in court, he is a psychologist who owned and operated his own independent practice located in Glastonbury. He provided psychotherapy to young children, adolescents, and adults, and he was enrolled individually as a behavioral health clinician provider in the Connecticut Medicaid program. Between January of 2017 and October of 2023, he submitted and caused to be submitted fraudulent claims to Medicaid for psychotherapy services that were purportedly provided to his Medicaid clients. Specifically, he submitted claims for dates of service when no services of any kind had been provided to the Medicaid clients identified in these claims, including when he was traveling, or on vacation, or recovering from surgery, or otherwise not working. He also submitted claims when an appointment had been canceled, or when the claimed client was in the hospital, or when he had stopped treating the claimed client, or when the claimed client had never been his client. In addition, when he treated multiple Medicaid clients in the same family at the same time, he billed Medicaid for the group visit as multiple individual claims, a practice that he knew was not permitted by Medicaid. The investigation revealed that he used his business bank account for numerous personal expenditures. Through this scheme, he defrauded Medicaid of over $1.6 million. The judge on the case ordered him to make full restitution. He also forfeited 16 pieces of jewelry, which he paid for using his business bank account, with an appraised replacement value of over $67,000. On January 31st, 2024, he pleaded guilty to healthcare fraud. He was released on a $250,000 bond, and he's required to report to prison coming up here shortly on June 24th. Now, mid-May also saw a hospice owner who was sentenced to 240 months imprisonment and ordered to repay $42 million for defrauding Medicare. A U.S. district judge on the case sentenced this Louisiana hospice owner to 240 months of imprisonment, 3 years of supervised release, and $2,300 in mandatory special assessment fees in relation to an extensive healthcare fraud scheme he orchestrated. In November 2023, a federal jury convicted this man of all 23 counts of his underlying indictment. He owned and oversaw the day-to-day operations of a hospice facility with offices in the New Orleans area, Baton Rouge, Covington, and Gulfport, Mississippi. At sentencing, the court found that between January of 2013 and December of 2019, the hospice billed Medicare approximately $84 million in fraudulent claims and was paid approximately $42 million relating to these fraudulent claims. The court ordered that the hospice owner repay the $42 million of fraudulent proceeds back to Medicare. On November 6, 2023, a jury convicted him on all 23 counts of healthcare fraud, charged in the indictment relating to overbilling for hospice payments for expensive general inpatient services and for multiple counts relating to manipulating Medicare billing codes, known as, of course, CPT codes, despite such services being medically unnecessary or despite their inclusion in the daily hospice benefit the hospice already received for its patients. Now, there were also many of the other usual suspects I talk about at the end of each and every fraud, waste, and abuse highlight month for these past 3 years. And these cases are including elder abuse cases, DME and telemarketing fraud schemes, opioids and pill mills cases galore, and even more kickbacks and bribery schemes. But I wanted to pay particular attention to a false claims case involving the DOJ resolving allegations that a Tacoma spine surgeon billed for unnecessary surgeries. Here, this resolution of a False Claims Act qui tam matter alleging that a Tacoma physician billed government insurance programs for medically unnecessary spinal surgeries. Two health systems will pay over $745,000 to resolve the matter, and the former orthopedic surgeon will pay over $197,000 to resolve the case. Now, according to the settlement agreement, on May 21st of 2018, another surgeon filed a qui tam lawsuit alleging that the spine surgeon in this case had been performing medically unnecessary spinal surgeries, among other allegations. One health system resolved claims that the hospital billed for his performance of spinal surgery at more spinal levels than necessary, and medically unnecessary spinal fusions at another Tacoma health system. Now, the spine surgeon resolved claims pertaining to his performance of allegedly medically unnecessary spinal surgeries. Between January 1st of 2013 and June 30th of 2018, these surgeries were billed to government health programs when they were not medically necessary. The surgeries billed were to Medicare, TRICARE, and the Veterans Affairs, the VA. In resolving this case, neither the doctor nor the hospital and the other health system are admitting wrongdoing. Each is paying the government health programs the amount that was improperly billed and additional penalties. Additionally, this other whistleblowing surgeon, as the relator who reported the false claims, will receive 22% of the payments to the government health programs. The spine surgeon in this case retired back in 2018 and surrendered his physician's license in 2019. The settlement resolved a lawsuit filed under the QTAM, or whistleblower provisions of the False Claims Act, which permits private parties known as relators to file suit on behalf of the government for false claims and to share in any recovery. Again, in this case, it's 22%. And now it's time for my best practice tips in Trusty Tip. Let's go over the new changes effective June 3rd, 2024 for hospice claims edits for certifying physicians. Be mindful that the Medicare administrative contractors, those MACs, will not be implementing these edits until October 7th, 2024. But in the meantime, make sure that your billing staff knows about these updates effective June 3rd, 2024. Now, there are two things that your billing staff should be aware of. Number one, that CMS will be paying for hospice services if certifying physicians, including hospice physicians and hospice attending physicians, are enrolled in or opted out of Medicare. And number two, the hospice attending and certifying physicians will be subjected to ordering and referring denial edits. Now, for claims that you submit on or after October 7th, 2024, with dates of service as of June 3rd, 2024 or later, those CMS MACs will check the referring physician NPI number field on the claim and the attending physician NPI number field on hospice claims to make sure that certifying physicians, including hospice physicians and hospice attending physicians, are enrolled in or opted out of Medicare. Now, those CMS MACs will also subject both physicians, if different, to the ordering and referring denial edits for the initial certification period. If the physicians are one and the same, they will apply the edits only to the attending physician field. Now, for the subsequent certification period, if both physicians are listed, they will check the referring physician NPI number field for the certifying physician. So you should be entering the attending physician in the attending physician NPI number field and the certifying physician in the referring physician NPI number field. If the patient does not have an attending physician, you should report the hospice certifying and recertifying physician in the attending physician NPI number field. And finally, I focus Season 12 Spark on collaboration. I want this 12th season Spark to be filled with our world's thought leaders, writers, artists, philosophers, everyone who inspires the need for better understanding of collaboration. So, in this week's inspiring quote in Spark is from Napoleon Hill. It is literally true that you can succeed best and quickest by helping others to succeed. Absolutely true, right? This quote reassures us that helping others in life and in work is key. This quote encourages us to reach a hand out and help others up. At every stage in our journey, it feels good to advise, to mentor, to collaborate with others. I'm happy Napoleon Hill's spark still burns brightly in all of us today. So that wraps up today's episode, and as always, I appreciate you all diving into today with me. If you want more information from me, please go ahead and follow me on LinkedIn. I'll leave links to everything in the show notes below. All right, you guys, remember to please catch my LinkedIn Live broadcast with my good friend and colleague Betty Hovey on Friday for our very last compliance capers in the month of May. We devoted this entire month on corporate integrity agreements. We're going to be wrapping up the month with 2 cases that involve violations of the Stark Law, the Anti-Kickback Statute, as well as the False Claims Act. A perfect end cap, right? An end cap on Paint the Medical Picture podcast and a perfect end cap for compliance capers. Don't forget, you guys, the full video versions can also be found on my YouTube channel for Paint the Medical Picture. So I wish you guys all an amazing and very, very happy week ahead. I'm going to be seeing you guys in the new month, the month of June, next week. Thank you so much for listening on today's episode, and I hope every week with me brings you closer to helping your providers paint a masterpiece. See you next Wednesday.